right, we will go ahead and get started. Good afternoon, everybody. We have some participants still coming in. My name is Annie Davidson. I've got with me a couple of new faces. You haven't yet maybe seen this year on our webinar series for Sanderson Firm. I've got with me Tracy Pendarvis and Deanna Lawrence, and we're going to be talking to you today about mitigation, Medicare set-aside pain points, and how to mitigate them. So if you haven't seen me before, I'm one of the attorneys here. I'm the Senior Vice President of Legal Affairs and Compliance, and happy to be doing a topic, dedicated to the allocation space and kind of mitigation within that. And then Deanna Lawrence is our VP of MSA Services here. So she oversees our clinical team. And then Tracy Pendarvis is our MSA trainer here. And Tracy and I go way back. She actually trained me in at a different company almost a decade ago. So really excited to be with her. If you've attended our webinars before, then you've probably heard this. We are proud to be women-owned. We have a national footprint, right? We're a law firm, but we have clients all across the country, carriers, self-insured, third-party administrators, government entities, you name it, we have it. We are comprised of legal, clinical, and claims professionals. So you've seen a lot of the lawyers this year. Now you're getting to see some of the clinical folks. These are our clinical experts. Tracy and Deanna have been doing this a while. They know all the things. They'll talk to you about it. You'll learn a ton. And we have over 60 employees now, 500 years of experience if you combine all of that. So you're in the right spot to get some really good information today. So I want to give the agenda. We're going to just go through a little bit of a level set, and then we'll talk about traditional versus non-submit MSAs. Again, part of that level set, kind of getting you grounded. Then we'll discuss the workers' compensation review contractor. And then we'll get into those pain points, the MSA reference guide that the CMS puts out, the WCRC allocation practices. We'll get all of that out there, because that really does show us, where mitigation opportunities lie, and kind of gives rise to a lot of those mitigation points. It also gives rise to non-submits, which is a huge part of what we do at Sanderson Firm. Of course, we do traditional MSAs and we submit them, but a large part of what we do is those non-submits. So they'll both talk a bit about, how we write those, what mitigation gets built into them. So that's the next on the bullet point list, is mitigation approaches and strategies, and then mitigation outcomes and impacts. So we have some samples and examples in here that they'll go through, and then we'll close out with a bit on re-review and amended review with CMS. Okay, so I've got the level set part, Medicare set-asides. What are we talking about? So if you're brand new, you just landed on this planet today, and you're a claims handler, or you're a risk manager, you're a defense attorney, and you've got to handle claims, and you've got to settle a case involving a Medicare beneficiary or somebody who's about to get on Medicare, you need to know what a Medicare set-aside is. So a Medicare set-aside is a bag of money that we hand over to that claimant when they're settling out their claim, right? And it's going to be used to pay for their future care. And it's going to be for future medical expenses that are otherwise covered by Medicare. We use these in workers' compensation and in liability settlements. They're certainly very well established in the workers' compensation arena, going back to 2001. Liability settlements, we don't have any regs specifically from CMS on them, but certainly they are needed in liability settlements from time to time. The underlying goal of doing this, why does Deanna and her team do what they do? Why does Tracy do what she does to help train folks in this? It's because at the end of the day, it's on the parties, and particularly the claimant, the plaintiff, the applicant, to make sure that they are coordinating benefits post-settlement with Medicare. So the goal is to establish an MSA fund and a pot of money, an amount, and we're going to estimate as accurately as possible the total cost that will be incurred for their medical expenses, again, otherwise reimbursable by Medicare, for the claim-related conditions over that person's life expectancy. And then we want to set that money aside, That gets set aside, that goes into a separate account, an interest-bearing account, hopefully, and it's not commingled with their other funds, and they use it to pay for their care when they treat for the injury post-settlement. So that's what we're doing. This came about originally back in 2001. So we're 24 years into this experiment, and there's a lot that's changed over the years. They're voluntary. MSAs are voluntary. They've always been voluntary, as is participation in Medicare's review process. Medicare is a voluntary review process. If you want to submit an allocation to Medicare, you have to have a Class 1 or Class 2 claimant in front of you. A Class 1 claimant is a Medicare beneficiary. They're currently on Medicare, and the total amount of their settlement is more than $25,000. In that situation, if the parties are settling for total more than $25,000, you can prepare an MSA and submit that to Medicare for review and approval. It has to be a funded allocation. Zero allocations you used to be able to submit to Medicare as of July 17th of this year. That's not the case anymore. Medicare will not review a zero allocation, period, full stop. Doesn't matter if you meet these thresholds. So then the other Class 2 claimant is somebody who has a reasonable expectation of getting on Medicare, right? They're going to enroll within the next 30 months. And the anticipated total settlement amount for everything is going to be more than $250,000. Again, you can participate in Medicare's voluntary review process with a Class 2 claimant like that. Can't be a zero, has to be funded. What do we mean by reasonable expectation? We mean somebody who has applied for Social Security disability benefits, right? So if you think about eligibility for Medicare, we're talking about people who are 65 years and older, or folks who've been disabled for 2 years or more. That's how you get on Medicare. In terms of being reasonable, having that reasonable expectation of getting on Medicare, you're talking about folks who are applying for Social Security disability benefits. Maybe they've been denied for SSDI, but they anticipate appealing that decision. They're in the process of appealing or refiling for Social Security disability benefits. If they're 62 and a half years old or older, that means in 30 months, they're going to be 65 and they could get on Medicare. So based on their age alone, they could get on Medicare within 30 months. And then finally, a claimant who has end-stage renal disease and who's not yet fast-tracked onto Medicare. There's a fast track onto Medicare for end-stage renal disease and Lou Gehrig's disease, ALS. The outcome with ALS is obviously it's a pretty fast progression and you don't typically see folks returning to work. With a kidney transplant, of course, we do see that. So there is a fast track onto that program. So that's what we're talking about. If you hear us talking about, submission thresholds, right? This is part of your level set. This is how you get to Medicare if you are wanting to submit and participate in this voluntary program. As a best practice, so if you think back, if you've been doing this some time, you think back to some of these settlements you might have seen over the years. I've definitely seen this. I may have helped folks do it. You've heard maybe across the board, hey, I've settled your claim for you for $24,999.99, right? The defense attorneys like to say this a lot. That means you don't have to do a Medicare set aside. Well, the reality of it is that was never a safe harbor. These workload review thresholds are not safe harbors. If you settle for $25,000 or less, or $250,000 or less with, a beneficiary or someone with a reasonable expectation, you've always needed to do something if that person needs future care. If they don't need future care, then you can write a zero allocation and, document your file and be done. But if they need future care related to the injury, you have to do something. You can't do nothing. As a general rule, you're looking to allocate funds for future care when future medicals are being released. The individual claimant is going to require care, Medicare covered medical care, as part of treatment for their injury. And they're either a current beneficiary or they have that reasonable expectation. This has always been your guide to when to do an MSA. People were using the workload review thresholds, particularly that first one, $25,000, as a safe harbor. That is irrelevant for determining whether it's appropriate to fund an MSA or even write a zero. So that's kind of my level set, my caveat here, but it's always been the rule. Medicare did debut reporting criteria in April of this year, April 4th, where now when you settle out a work comp claim, you're not only sending the settlement amount, you're also telling them of that settlement amount, how much of it's for future care. And that's any settlement over $750 with a beneficiary. These workload review thresholds are just that, thresholds to participate in their voluntary program. Okay, I am done with my level set. On to the real show. I'm going to turn it over to Deanna Lawrence to kick us off for the mitigation information and the process before we get there. Deanna?
Good morning or good afternoon, wherever you may be. I want to talk a little bit about the Workers' Compensation Review Contractor of the WCRC. What do you do with the MSA after it's been provided to you? If you decide that you need to submit it, the WCRC is responsible for reviewing that MSA they base the proposals on CMS's hat. Currently, Capital Bridge serves as the WCRC, and they've held this role since 2017. Their contract was renewed in late 2023. And since that renewal, we have not seen any significant shifts in the allocation trends, and things have remained relatively consistent. So in terms of responsibilities, the WCRC's primary role would be to review the proposed WCMSA, evaluate whether it's adequately protected Medicare's interest, and then provide recommendations to CMS. So after they review and provide those recommendations, CMS then makes that final determination on a file. So before we dive into allocation specifics, it's important to understand, next slide please, how CMS and the WCRC approach MSAs. To fully grasp that potential MSA exposure, especially when using that voluntary submission process. So we just need to understand that philosophy and what guides their reviews or their decisions. And just a quick reminder that the philosophy, along with the allocation process, is detailed in that WCMSA reference guide that Annie just spoke about, and it serves as an official framework or guide to use and how MSAs are reviewed and how they're approved. So now let's talk about what it means to actually practice and some of those key challenges that we have identified here. CMS and the WCRC take very conservative approaches when reviewing allocations. So several of their standard practices often drive those MSA amounts higher than what we expect based on real-world treatment patterns. So one of the most frequent challenges we encounter is medication weaning. Even if a provider outlines a plan to taper or discontinue medications in the future, for instance, like opioids, one of our major cost drivers here, the WCRC usually does not assume that weaning will be successful. The WCMSA reference guide recognizes drug weaning, but generally does not factor in its success when reviewing MSAs. They don't have a crystal ball. They just assume that it may or may not work. So we're going to err on that side of caution and make sure all those medications are in there that are needed. So even with the documented tapered plan from that treating physician, CMS often assumes the claimant will remain on that current dosage for their lifetime. And that can significantly inflate the drug cost or the Medicare Part D of that allocation. Another major driver of the inflated MSAs are allocating of unlikely treatments. CMS does not typically recognize, or I haven't seen them recognize in my 20 plus years, of any permanent waiver provided by the claimant, saying that they don't want medical services or they never will seek them of XYZ service. That reference guide is very clear on this point, and that goes in to say that if the claimant has no intention of ever pursuing a certain procedure or treatment item, as in spinal cord stimulators, intrathecal pain pumps, or even surgeries, those treatments will most likely be included unless the treating physician explicitly rules them out. So CMS trends allocate for ongoing treatments at their current frequency across the claimant's entire life expectancy. And you can see how that can quickly inflate an MSA. They make no allowance for improvement, decreased needs of treatment, or even a transition to a more conservative approach. So for example, if the claimant is currently seeing a provider every 3 months, CMS assumes quarterly visits will remain over that life expectancy. Regarding non-beneficial treatments, if injections were provided without significant benefit, repeat injections could still be allocated without physician clarification. So in real world scenarios, we know that treatment frequency usually declines over time, or even changes when it's not being provided a successful outcome or any benefit to that claimant. But CMS doesn't typically reflect that in those projections. So another common issue comes from ambiguous language in those medical records. When the medical records are vague, let's say a provider says may consider intervention, surgical intervention, or evaluate for stimulator. CMS will typically include that full cost of those procedures, even if it's not an actual recommendation. Let's maybe say they discussed it in those records. So around here, we say that if the records don't rule it out, CMS will build it in. And that's why it's so important to ensure that providers are clear and specific in their recommendations. So let's talk more about non-submit Medicare set-asides or non-submit MSAs. Like the traditional MSAs, these allocations set aside a portion of the claimant settlement, just like Annie explained, to cover future medical expenses related to the injury, expenses that would otherwise be covered by Medicare. The key difference here is that it's not submitted to CMS for review or approval. Instead, they're developed using evidence-based medicine or guidelines, meaning clinical best practices and medical literature guide for that allocation. So these MSAs focus on what's reasonable and necessary from a medical standpoint. And it's important to note that Medicare itself recognizes this rule of medical evidence. As you can see here listed on the screen, the WCMSA reference guide reinforces that using medical evidence-based practice is not only acceptable, it's consistent with Medicare's own policy framework. When a non-submit MSA is built on sound medical reasoning, there's that evidence to support removal or decreasing of treatment. This follows accepted clinical guidelines, and it's clearly documented in this MSA, and it's defensible if it's ever questioned. We have seen MSAs or non-submit MSAs becoming increasingly popular among the workers' compensation payers, and for good reason. The main drivers that we see behind this trend include these three listed here. So lengthy CMS submission turnaround times, which can delay settlements. There's a limited ability to appeal CMS determinations once they're issued, and we'll discuss that further later. And lastly, CMS can issue counter high allocations, meaning that they increase the proposed MSA amount, and sometimes it's significant. So many payers are turning to these non-submit MSAs simply because CMS's process is very rigid and can often inflate the cost over the life expectancy. So I want to talk about some cost-saving examples that CMS often assumes a claimant will remain on that same opioid dosage and frequency for life, like we talked about earlier, even if there's a plan in place to taper or discontinue that use. By aligning with current treatment guidelines, evidence-based MSAs help avoid overfunding while still protecting Medicare's interest. Another example, CMS does not recognize certain state-specific statutes that limit future medical care in states like Georgia and Maine. However, if you choose to submit to CMS, those statutes are not only honored, are only honored if there's a court order in place and that's provided. With a non-submit MSA, we can apply those statutes directly without having to go through legal hurdles to attain additional supporting documentation. That flexibility can make a huge difference in how settlements are structured and even approved. Tracy's going to walk us through some of our key considerations when handling MSAs.
Thank you, Deanna. So when we talk about high cost drivers in our MSAs, our Medicare set-asides, the biggest culprit tend to be surgical procedures, your injection therapy, and frequent office visits. Let's start with the spinal cord stimulator, the intrathecal pumps, and surgeries. If these are mentioned but not yet performed or the intent is unclear, always confirm with the treating provider. Just don't assume surgery will occur. We'll want to evaluate the medical necessity using our evidence-based medical treatment guidelines. Next, we'll take a look at injection therapy. The WCRC allocations are typically based on the current frequency if continuation is noted. That means if injections are documented every 3 months, that cadence is projected for life, unless documentation supports discontinuation. So confirm with the provider whether the treatment can be reduced or discontinued. And then finally, our office visits. While they seem minor, monthly visits can compound into a huge future cost over lifetime. Clarify with the provider. Can visits be reduced? Is as needed follow up more appropriate? Has care already ended or transitioned? Prescription medications are another major cost driver. Weaning is often discussed, but CMS generally, they will not accept a weaning plan unless it's clearly documented with specific timeline and a dosage plan. So before submission, work with a treating physician to outline that timeline and always use the lowest effective dose. Next, let's consider brand versus generic substitutions. A brand to generic switch can cost or cut costs by more than half. For example, take a look at Celebrex versus its generic alternative. It shows a dramatic reduction. Also, over-the-counter alternatives, these are not included in the MSA and can represent a legitimate cost reduction when clinically appropriate. Now we'll move on to dosage and formulation optimization. A lower dose or extended release version can be significantly less expensive while maintaining the same clinical effect. And finally, let's look at therapeutic equivalents within the same drug class. For instance, switching from tizanidine to cyclobenzaprine. Now let's step back and talk about the broader proactive approach. So success starts with planning early. Mitigation opportunities are strongest before the referral for the MSA preparation. Use a team approach. Claims professionals, your nurse case management, utilization review, defense counsel, and the MSA vendor should be all aligned. Leverage utilization review to support evidence-based medical treatment decisions, and always confirm treatment relatedness to the accepted body part or condition. Utilize your MSA experts, right, for guidance. And above all, identify those cost drivers early. Be on the lookout for those high value interventions that can inflate costs if left unaddressed. So one of the most important balancing acts in MSA work is really between the treating physician's opinion and evidence-based medical treatment guidelines. While the WCRC weighs guidelines, the treating physician's opinion still carries the greatest weight in those medical records, right? Use your ODG, ACOM, or state-specific guidelines to support discussions with providers, advocate for medically appropriate changes, and strengthen the defensibility of your MSA. Always research jurisdiction-specific rules so you can back your position with objective, credible sources. When considering provider outreach, always weigh whether it's appropriate. Consider litigation status and consult the defense counsel. Uncoordinated outreach can backfire. So determine who should perform the outreach. It might be the adjuster, a defense attorney, case manager, depending upon the jurisdictional rules. Be aware of ex parte communication restrictions and your claimant's representation. After outreach, document everything. Let the provider's opinion be in writing. If medications are changed, CMS may require 3 months of consistent fills to support that modification. Remember, documentation is key to your defensibility.
I just want to chime in here for a second with that defense attorney hat on, because that's what I did when I was in private practice. And I practice in Minnesota, and, you know, reaching out to the providers isn't kind of the name of the game a lot of times, but I would use this mitigation information. So with any MSA that you're getting from us or from another provider, you should get mitigation opportunities, and that comes from us. We will definitely lay that out for you. And when I was a defense attorney, I would take that in Minnesota and I would go back to my opposing counsel and say, hey, look, we're definitely interested in settling, but I need your help. Your client is taking X and this is a brand. Can we get them over with this generic? Or they're taking something that we could switch to over the counter. Kind of going back to that last slide that Tracy went over, these are tools in your toolbox if you can't use all of them. But I do think, Tracy, I love that you're pointing out, right, is the outreach appropriate? Because there can be those negative impacts. And when you're submitting to Medicare, Medicare will sometimes want you to create a record where there isn't one, like prove the negative, that this person hasn't treated in so many years, or so much time, and they want you to send them back to the doctor. We all know as claims handlers, as risk managers, as defense attorneys, the last thing I want to do sometimes is send that claimant back to the doctor, because who knows now what could be considered related to their injury. So there are, pros and cons to doing any of these things. But if everybody's on the same page, knowing that you need to do an MSA from the outset, you're mitigating stuff as you go. You're certainly looking out at the time of MSA, on how you can get even more mitigation if need be. So really great points, Tracy.
Thank you, Annie. Okay, so let's look at a real world case. So let's just kind of break one down. This one, we have the claimant had chronic low back pain and was noted as a potential candidate for a spinal cord stimulator. But when we reviewed the records against the ODG criteria, there were several red flags that appeared. So conservative treatment hadn't failed. It had not failed, right? The psychological evaluation was not documented, and severe depression raised some candidacy concerns. After clarification with the provider, we confirmed that the spinal cord stimulator was not medically appropriate, and by removing it from the projection, we achieved a savings of $138,000. So this case shows how guideline validation can transform an inflated MSA into an accurate, defensible allocation. Let's move on to the second one. Okay, so this case, this one is ambiguous medical language that has inflated the cost. So the notes mentioned the claimant was an appropriate surgical candidate, but didn't specify which surgery or which procedure, right? Without clarification, that could translate to a lumbar fusion costing nearly $70,000 when the provider may have actually meant a laminectomy at half the cost. So we did contact the physician, clarify the recommendation, and align the records to the correct surgical plan. And I think that's very important, aligning those records to the correct surgical plan. That resulted in $35,000 in savings. So it's a simple example, but it underscores the value of clear documentation and early outreach.
Absolutely. And I want to point something else out here on this diagnosis. The diagnosis here looks like low back pain. When you're working up your files, or you have claims handlers or your TPAs working them up, this is a diagnosis that we hate to see entered into like Section 111 purposes, right? It may show up in the clinical side. It may show up in office notes. That's fine. But I would be careful if you're going to use this note for your ICD-10 reporting via Section 111. You want to kind of focus on an actual diagnosis, right? If they had underlying stuff going on with their low back, not only can vague notes, lead to the situation where you don't know which kind of surgical intervention is needed, it also could have you picking up and paying for things that could be related to, something that's, personal and not related to your injury. So if you think it's like a shoulder pain and they have underlying shoulder arthritis, if you say shoulder pain, you're going to be kind of in muddy waters. You could see conditional payments coming up and all those types of things. Whereas if you focus on the sprain aspect of it, or a partial tear, if you're really specific, so just a caution when you're looking at these notes to make sure that you're doing more. Because of course, MSAs touch other parts of Medicare compliance now. We kind of used to live in silos with the different areas of compliance, and that's not really the case anymore. Okay, moving on.
All right. Okay, here's another great example. This time involving medications. The claimant had postoperative ankle pain, and medications from surgery were still listed as active, like years later. I know we've all seen those claims. By verifying with a physician, we confirmed those prescriptions had been discontinued actually long ago. Removing them from the future treatment plan created a potential savings of greater than $350,000. Your prescriptions will get you. So definitely want to put a lot of emphasis on those. Always remember your medications, they tend to linger in the records. And if you don't verify them, CMS will assume that they continue indefinitely. So the best outcome happens when our claims professionals, legal team, and the vendors all work together proactively before the MSA ever lands on CMS's desk. Now I'll hand it back over to Deanna to see how Sanderson's firm can meet your needs.
Thanks, Tracy. You're right. We've all seen those cookie cutter medical records that list those medications over and over and over, and there's nothing to support, no payments, nothing on the payment history or the drug refill history showing that those medications have continued. So good point there. But yeah, here at Sanderson Firm, we understand that every claim and every client is different. And that's why we offer tailored Medicare set-aside options that are designed to match individual organizations' specific needs and their risk tolerances. Every MSA we prepare undergoes a comprehensive expert review. We identify key cost drivers and potential risk exposures. Then we can work with our clients to develop targeted mitigation opportunities to help reduce those costs to a more realistic outcome. Our recommendations are backed by evidence-based medical guidelines that ensure every proposal is defensible and compliant. We also provide our clients with access to our medical mitigation support tools, which help drive those real savings that Tracy was just explaining. Our mitigation process is proactive and collaborative, and we offer a few options here. So option one, I want to talk about that our team reaches out directly to the treating physician, obtaining a completed treating provider questionnaire to clarify ongoing treatment needs. So we would write up that letter and then also provide it to the physician and with periodic follow-ups. This helps strengthen that documentation to support a cost reduction and ensure that the medical record accuracy or accurately will reflect current and appropriate care and then future care. We could also prepare a formal treating physician letter that our clients then send directly to the provider themselves. This letter can outline, like earlier, the same type of letter that potentially can change the treatment that's projected with clarifications that support MSA mitigation. So this will help ensure that that medical file, again, aligns with real-world treatment plans. Our experienced clinical team knows this industry well, and we're able to approach the physician letters in a strategic manner while engaging that physician and understand that what CMS is likely to favor. Our goal with our medical mitigation support is simple. We want to maximize savings and ensure full Medicare secondary payer compliance with our MSAs. So I want to take a look at how CMS re-review requests work, as they are allowed only under very specific circumstances that are listed here, and only once per category. There are 3 types of re-reviews that can be submitted, and each of these categories serve a unique purpose, and it's important to understand when and how each one will apply. So the first one, the mathematical error, this applies only when it's a clear, verifiable, numerical miscalculation in CMS's pricing and that determination that we received. It's important to note that simple disagreements over what CMS included or excluded, such as specific treatments or medications, they don't qualify under this miscalculation. It's just basically numerical and only numerical to be eligible for this medication evaluation review. Mathematical error calculation review. The second category is a missing documentation. So this applies when you have additional documentation that was not included in the original submission, but the documentation must meet the following criteria. It must be dated prior to that original submission date, and it must be newly provided. So it can't have been already provided to CMS in that previous packet. It must be significant enough that it could materially affect the CMS's determination. And the third category is a submission error. This applies when there is an error in the documentation itself, something that caused the pricing to be off by $2,500 or more, and to qualify, the corrected documents must come from the original source, clearly show the correction date, and include a handwritten or wet signature confirming that change. I also want to note here that the re-review category, the submission error, it only applies to CMS approvals dated September 1st, 2022 or later. And another important point to remember is that you can only submit one lifetime review request per each type of error.
And I just want to chime in here as someone who's worked on various different types of re-review requests. I mean, mathematical error, pretty quick to kind of get back to CMS and point that out. Submission errors too, right? If there's just been an error. But that missing documentation one, it's important, and you don't always have all the records you need to go at the time you go to CMS. But again, like Deanna said, if there's something that predates the submission, you can go ahead and provide that. It's essentially, you know, a meaningful piece of evidence that wasn't in front of them, and it's going to change the outcome of the allocation. That's another important thing to remember is when Medicare is approving an MSA, when you participate in this process, it's not that they're approving all of those particular drugs and types of treatments. Tracy and Deanna are showing their work. When we write these Medicare set-asides, you're showing your work on how you get to a number. Medicare ultimately approves an overall number. If the number that we submit to them is within 5% of their number, they're going to let our number go forward. So there's lots of different kind of pieces here that happen when you're participating with Medicare's review process. What's nice now is if you were missing that documentation and it was something that didn't exist, but let's say, you know, it was that spinal cord stimulator example. You submitted and Medicare's trying, you know, going to put a spinal cord stimulator in there, right? They came back with a determination putting it in. And then that letter that Tracy talked about, they get that from the doctor, taking it off the table, but it post-dates the determination and the submission. You used to have to wait at least 1 year. And then in the past, it was longer to go back for what's called amended review, which Deanna's going to talk about in a minute. You don't have to wait that long anymore. So that it doesn't hamper you the same way that missing documentation did in the past. So these are all great tools to be aware of, and this is something that we're all over. When we get a determination in, we're looking at it to make sure there's no mathematical error. That's the benefit of working with a vendor, right? We're going to look at that. We're going to see what's going on. Was there documentation missing? Was there a submission error? And then also, when you get an MSA from us or any other vendor, look at it before it's submitted to Medicare. Make sure that it accurately reflects the admitted conditions, the denied conditions, all of that stuff. And then look at the determination when it comes back too. It's got page upon page from Medicare, and there's some key pages in there where you can look to see like where their math is a little bit different than our math, right? And we can figure out if there's errors in there. So very important to be looking at this documentation. Okay, let's move on to some successful re-review examples before Deanna talks to us about amended review.
Yeah, thank you, Annie. So these cases show that when supported by that right evidence and documentation, a re-review can lead to significant reductions in that approved MSA amount. So in this first example, the Georgia 400-week medical cap for non-catastrophic claims was successfully applied via court order, leading CMS to remove unrelated future care. So this showed how a state statute can significantly impact that MSA outcome. So when this was submitted, the court order was not supplied. The client had it, but wasn't supplied in with the packet. So we came back and resubmitted it. The date was prior to that submission, and this was a successful outcome. Our second example involves a rated age correction. In this case, the incorrect rated age led to a miscalculated life expectancy. So after obtaining that proper documentation from the settlement broker and submitting a re-review, CMS updated that pricing, removed that 1-year life expectancy, and it lowered that overall MSA amount. Example 3 here, a CMS typographical error. This one is simple, but it really impacted the overall allocation. So CMS had mistakenly included 4 radiofrequency ablation procedures instead of 1. And that typo was identified, the evidence was provided through that re-review, and CMS corrected that mistake. So that correction led to a substantial reduction in that overall allocation. In the fourth example here, listed future care for a left humerus fracture was excluded after a court order confirmed that it was unrelated to the work injury. So CMS accepted that exclusion through the re-review process, and it reduced that overall MSA amount. And the last example shown here is when a neurologist visits that were deemed personal in nature and not related to the compensable injury, and were also excluded with a favorable outcome. So each of these examples just demonstrates that value of a well-supported re-review. When documentation is clear, relevant, and timely, we have found really good success with CMS willing to make corrections, and those corrections can lead to significant savings. So now I want to talk about the amended review process. There's things to consider before submitting an amended review process, and Annie did touch on these, but the case cannot have settled at that time of request. There is a significant change in the projected future care that will cause at least a 10% or $10,000 change, whichever is greater, from that previously approved CMS amount. So some important notes to keep in mind that this is a one-time request only. So it's very important to submit it when that change is clear and justified. There's no murky waters when you're doing with the amended review. The new approval amount will apply whether it represents an increase or a decrease and from that original amount. And CMS will not issue development letters during an amended review. So that process is a bit different from that initial review. It's a one-shot deal here. And although CMS review process is still available after the amended review if needed. So if you do find out where, there's a documentation that wasn't submitted, that's predated that submission, you can still do that here. And finally, amended reviews can be submitted even if the original CMS submission was already approved. So this isn't only limited to cases where CMS issued a counter hire. And I also want to highlight here that as of April 7th of this year, the 1-year waiting period has been eliminated. Just like Annie was saying, now that you can submit an amended review immediately after a determination is made and you no longer have to wait. So now I want to show some, oh, go ahead.
Oh yeah, I was just going to jump in for a second. So I really pushed CMS on this 1-year thing a year ago at the National Medicare Secondary Payer Networks Conference in Baltimore, because this was, such a huge problem when, especially in like the example that Tracy gave, where you had a spinal cord stimulator that got priced in, but you have something that very clearly allows you to yank it out. The question I basically had for them was like, why are we making people wait a year? They get one bite at this, the one extra bite at this apple. Doesn't matter if it's been 2 months, 6 months, a day, a year. And so CMS did change that, like Deanna said, as of April 7th. The other thing to keep in mind here is anytime you're working with submissions, please know that it is not Sanderson firm. It's not a different benefit. No one is being super persnickety and telling you need X, Y, and Z because we think it's fun and we want to make your life terrible. No, CMS is super hardcore about what they want when you're submitting. Your records have to be dated within 6 months of your date of submission, but then also the date they ultimately end up reviewing it. So if it hits development, you heard Deanna say, development's not available here. If you don't know what that means, it means if CMS is missing a piece of information, a record, something that they need to complete their review, they will issue a development letter with a normal submission and stop their review process until they get a response. With this amended review, you don't have that shot. So if you're going for amended review, any vendor is persnickety about helping you with a regular submission, but they're super persnickety about this. If you don't have what you need, I will get on the call, like an attorney will get on and we'll talk with you because we do not want you to blow your one shot at doing this.
Right.
If you submit something for amended review and it doesn't have what it needs, all Medicare is going to do is kick out an updated copy of their old determination. And that's what you're stuck with. Now, you're not bound by any CMS determination, but it's a pretty strong piece of evidence out there telling you about future care. So it's kind of hard to ignore it. But that's something to keep in mind is they'll just update that letter then and they'll say, you submitted some stuff. We didn't have what we needed. By the way, you're stuck with this amount from, 10 years ago. And that's it. And you've blown your one shot. So just a caution there with these amended review requests around that. Okay, sorry, Deanna, back to you.
No, you're fine. I just wanted to talk about or show some examples of amended review successes that we have seen here at Sanderson Firm that have led to some really big savings. The first case in the original CMS approved amount was over $228,000. And after submitting an amended review that removed the psychiatrist visits and made changes to discontinued some medications, the savings was nearly $200,000. In that second example, the original CMS approved amount was just under $60,000. The amended review focused on reducing the neurologist visits, stopping some of the medications that weren't approved supportive, and removing related lab work, which resulted in a savings of over $18,000. In this third case, it started with an original MSA approved amount of about $109,000. The amended review successfully removed family medicine and surgical procedure, leading to a savings of more than $46,000. So these three examples here just show the power of the amended review process. They highlight how targeted changes to treatment plans backed by that clear documentation we talked about can lead to significant reductions in CMS approved amounts, ultimately lowering the overall settlement exposures. So to wrap up here, some key points to keep in mind that before deciding to submit to CMS, make sure that you weigh the potential benefits against the risk of getting a higher, less flexible allocation without that clear documentation. CMS will often include that full cost of the interventions or medications or whatever that may be that's may slightly vaguely be mentioned in the medical records just to be safe. So remember, vague records equal bigger MSAs. Let's see, evidence-based MSAs are strong and defensible because CMS itself supports using evidence-based approaches. It says that in that WCMSA reference guide. And in short, knowing those options and when you can use them can save you time, reduce your cost, and keep you fully compliant. Non-submit MSAs aren't just a backup plan or something you can use after WCMSA, but they're a strategic tool, just as Annie had said, in our toolbox that realistically projects that future treatment and protects Medicare's interests and still drives smarter, favorable outcomes or real-world realistic outcomes. So I hope that you found this webinar helpful today. And now I'm going to hand it over to Annie to tell you more about our next webinar.
Absolutely. We still have time for questions. So throw your questions in the chat. You've got a moment here while I talk about a few other things, and then we'll get to questions. So our next webinar is coming up. It will be in November, on November 19th. I will be on that webinar, and we will have a guest from Ametros on. Sean Dean plans to join me on November 19th. So we'll be talking about not only just Medicare set-asides, right, including IMSAs, EMSAs, you name it. We'll be talking about those things. But we'll be talking about post-settlement administration of those funds and, you know, reversionary clauses and those types of things. So tune in on Wednesday, November 19th for that webinar. If you want to just receive or be registered for these webinars automatically, send us an email at spotlight@sandersoncomp.com and we'll get you registered. Even if you can't make it to one of our webinars, if you're pre-registered, you'll get a copy of the recording after the fact along with any other materials that we hand out. And then before we get into the Q&A section, we've got all of our services here on the screen for you. We have, all of these items, right? We've got stuff that falls into the allocation category. We've got conditional payment and lien resolution services, Section 111. We do it all, right? And other legal services. I just wrote an expert opinion letter in a liability case a couple weeks ago. So if you ever need, help with that kind of stuff, we've got it. If you were on our webinar last month, you saw that we are really happy to share with you that MSP College is going to be doing a live MSPA event. MSPA is an accreditation. It's the Medicare Secondary Payer Accreditation. It's an option out there. If you look at Tracy's name and Deanna's name and my name at the beginning, we've got credentials behind them. Some of them are our legal credentials or our nursing credentials, and then some of them are our certifications living in this Medicare secondary payer world. So MSPA is a designation that goes beyond it. We also have an MSACP, which I'll talk about just in a second. But we are going to be live. This is usually an online learn at your own thing. We are going to be live in person conducting this certification, this accreditation, or at least the modules for it before you take your test from January 12th and January 13th, 2026. We will be in Tampa. So if you live in the Midwest like me, oh no, I have to travel to Tampa in January. Think about joining. We only have 40 seats available, and several of them have been taken up already. If you have questions about it, shoot us an email down there, give us a call. Happy to field those questions. What is MSP College and MSPA? MSP College is a place where you can get a couple of different certifications. The MSPA certification, which you just heard me talk about. This is claims professionals, defense attorneys, you name it, looking to enhance your MSP knowledge. We talk about all different areas of Medicare secondary payer compliance. And you can complete it at your own pace. If you do it online, it's online and on demand. Of course, we have that live one coming up where you'll get all of the modules over a day and a half worth of training, and then you go home and take the test. MSP College is also proud to offer the MSACP accreditation. This is for those of you who want to enhance your MSA knowledge or would like to begin a career in allocating MSAs, doing what Tracy and Deanna do. It's online and on demand. We don't have a live in-person version of this yet, but if there's a ton of interest, it's something we could certainly think about. You complete it at your own pace. You will see Deanna's face is in there. She's helping train you, and some other great folks from Sanderson firm and elsewhere in the industry. We'll talk through all of the courses, again, at your own pace. Once you complete the course, you'll have all you need to know to be able to develop and write a Medicare set-aside and be able to submit it to Medicare. We've got our thank you slide up. This is contact information for us. We'll make sure that you get a copy of this, but we've got about 5 minutes here. So I'm going to go ahead and I'm going to stop sharing my screen, and I'm going to go and I'm going to look at the questions that we might have. Or maybe I don't have to stop sharing. I'll just pull up the chat, and it looks like we've got a question in the Q&A. So yeah, I'll start with that one. The Q&A question: if you're not submitting to the MSA for CMS review approval, are the same mitigation strategies needed, or does Sanderson build those mitigation items into the MSA calculation result anyway, without, for example, the treating doctor clarification? Deanna or Tracy, can you answer this one for us?
Sure, and I think I understand the question. We identify with each MSA any key cost drivers or potential risks that we see if submission, or even if you're not submitting, with all of our files. We provide a generalized number of what could happen based on a successful physician mitigation or medical mitigation practice. We don't know exactly if we're asking more than 1 or 2 items in that medical mitigation. We don't know exactly what they're going to say. So it's an approximate evaluation of what could come back.
Yeah, so I mean, generally you would think of evidence-based non-submits as, building in as much mitigation as we feel like we have clinical foundation for. So that's the thing, if you're not familiar with, the total difference between evidence-based, I mean, obviously Deanna talked about it and Tracy talked about it, but it's really, for me, when I was in private practice, it's this idea of like, what's happening with this person for real versus Medicare's kind of world that they live in. I think evidence-based medicine gets us there, but then also we can bake in the real world items. If a person has said they don't want to have the surgery and it's been recommended, if they've documented that, we won't necessarily put that surgery in. Medicare is going to put it in. Medicare is looking at that worst case scenario, what could happen. And realistically, under the statute, you have to reasonably recognize Medicare's interest. We're doing that. An evidence-based MSA has a clinical foundation. It has a pharmaceutical foundation for what we're doing. If there's legal stuff involved, there's a legal foundation. And so that's why we believe so strongly in them. Deanna, Tracy, one of the questions we have is there advice on how one would decide between an evidence-based MSA and an IMSA? Can you talk a little bit about that?
So the evidence-based and the EMSA that we call them, or the IMSA, they are allocated the same. They both apply evidence-based medicine to them. The IMSA, or indemnified, is where Sanderson firm actually indemnifies that MSA. But the allocation numbers come out to the same.
Yep, they're written the same. So you're good either way. It's just really whether you're going to submit it or not, and an EMSA is meant for submission, or you could settle with it without submitting. And what I like about the EMSA is it puts pressure on Medicare to get with the real world. Basically, Deanna and Tracy are telling them, hey, look, you said you were going to consider some of this evidence-based stuff. We just gave you the foundation. We showed you where in ACOM, ODG, whatever, we're giving you the foundation to support you actually following evidence-based medicine. To me, it puts their feet to the fire and gets them doing what they said they would be willing to do. We will send out a copy of the presentation, so I thought that was in here. Are we currently seeing any delays with CMS approval due to the federal government shutdown? No. So Medicare is fully funded. CMS is fully funded, as are their contractors. So the WCRC is fully funded. There should not be any delays due to the federal government shutdown. Great question, though. Next one up, we have maybe time for one more question. If we didn't get to your question, we're going to answer it offline. CMS is including ketamine infusions and approvals, but ketamine infusions are not covered by Medicare. Why isn't ketamine instead being allocated in a non-Medicare allocation? So quickly, with a Medicare allocation, it's the Medicare covered items and services. Along with that, we provide a spreadsheet of non-Medicare covered items and services. So that's something that just to be aware of. That's maybe what this person is talking about. But Deanna, can you talk to us about ketamine and how CMS views it? Would it go in? Would it not go in? How does that work when something's covered or not covered by Medicare?
Yeah, so typically when things are not covered, you're right, would be on a non-Medicare allocation report and not included in that MSA. We have not seen where ketamine infusions are coming back in our approvals. I would definitely try to talk to CMS about this. I know it's a little bit hard at this time. Maybe apply those evidence-based guidelines. Or was there an off-label use on it? Or maybe it was just a miscalculation on their side as well.
Yeah, it could be an error. All right, well, we are at time. Thank you all so very much for your time today. Thank you, Deanna. Thank you, Tracy. We hope you found this interesting and engaging. Please fill out the survey that will pop up on its own when we end this, and we look forward to seeing you at our future webinars. And if you have a question in the chat that we didn't get to, we will email you afterwards with an answer. So thanks, everyone. Have a great rest of your day.